Hi, this is Rick Frederick reviewing Clark v. Arizona, 2006. This is a United States Supreme Court case. And it's difficult to understand and very frustrating to read. And one of the reasons why is because there's a general sense in most of the country that insanity defenses are an essential right, that it's unfair to prosecute somebody and convict them of criminal behavior when they weren't able to appreciate the nature and quality of their actions or conform their behavior or whatever standard you might apply, that there's something inherently unfair about that. But to read Clark v. Arizona, I think it's important to begin with. There are 4 states where you can't even use an insanity defense. There isn't an insanity defense. And the Supreme Court has never said that that's unfair. It didn't. It denied certiorari in Dowling v. Idaho, in which somebody was claiming that it was unfair, so that they have never recognized that the insanity defense is a fundamental principle, a fundamental right under the Constitution. Competency, yes. You must be competent to stand trial, or it's a violation of due process. But it's not a fundamental principle that you should be able to plead insanity. So in Arizona, you can plead insanity. You can have an insanity defense, but it's so narrowly restricted that what makes Clark v. Arizona difficult to read is that it seems terribly unfair. And that the language and the reasoning that Arizona has developed around the insanity defense is rather tortured and strained to the point that it's ridiculous. So here we have in Clark v. Arizona a defendant who is a juvenile, who is seriously mentally ill. No doubt about it. No doubt that even at the time of the crime he was severely mentally ill and was sent to be restored for competency, I think taking 2 years to restore him to competence to stand trial. No doubt that we have a person with severe paranoid schizophrenia who has profound paranoid delusions that were present when he was jailed, when he was arrested, that almost led to him starving himself to death. There is no doubt that Clark was seriously mentally ill when he shot and killed a police officer, and that his reasons for doing so were the product of a mental disorder. But that's not the law in Arizona. It's not the law in Arizona that if your behavior is the product of a mental disorder, that you're acquitted. It's really not the law in most places anymore. But one of the things, well, let's just continue. We'll come across this. Clark argued that he didn't know he was killing a police officer. This was disputed at trial. So there really wasn't compelling evidence that he didn't know he was shooting a police officer, and it makes sense. It's a reasonable argument by the prosecution here that Clark had told others he wanted to kill a police officer, that he did something that would attract a police officer. He lured a police officer. Why he did this appears to be the crux of the matter. And it may have to do with he believes that aliens have populated the earth, and he needs to do this or that. He's a delusional person with irrational thinking about the whole thing. Okay, so Arizona's insanity test is kind of unusual. It includes only the wrongfulness prong of the McNaughton standard and not the nature and quality prong. So if you know that you're killing a police officer, that's not exculpatory. If you know that it's wrong to kill a police officer, then it's exculpatory. And the next thing is that there's this very strange process by which testimony can be offered in Arizona cases. If you just think about why do they have this? Well, probably the reason is that they're trying to restrict the use of a diminished capacity defense. I mean, even in the federal system, you can't get a diminished capacity defense for a violent crime. And so Clark wanted to offer certain mental health testimony, but he wasn't allowed to because of a ruling in what's called, or a Mott rule, which is from State v. Mott. Arizona didn't allow mental health testimony to negate specific intent. Okay, so if you think about the elements of the crime, one of them is specific intent. He had to form specific intent to kill a police officer. And he wanted to offer mental health testimony to negate that, but the state of Arizona doesn't allow that. And you can say, well, that doesn't make any sense. And I agree with you, but the question before the Supreme Court is, does that violate a fundamental right under the Constitution? And what the Supreme Court is going to say is no. So the issues were, does due process prohibit Arizona from using insanity tests solely in terms of capacity to tell whether the act was right or wrong? Well, if there's, it'd be very shocking if the Supreme Court said yes to this, because if they denied cert in Delling v. Idaho, or go back to Powell v. Texas, Robinson v. California, they're very clear that they don't want to set a precedent whereby they identify a fundamental principle that you can plead insanity. So then the next question is, does restricting defense mental health evidence to the issue of insanity violate due process? And they say no. So they upheld Clark's conviction, and just in reviewing the reasoning of the majority, I think this was a 6-3 case. Look, there have been many constructions of insanity. So this is their first response. There are many constructions of insanity. And so given the wide variability in how people construe insanity, Arizona's construction could not be considered a violation of a fundamental principle. And then secondly, this idea that an expert, this is very difficult to understand, but an expert couldn't offer evidence to negate a specific intent element of the crime. I think the best way to understand this is to go back and look at a case like Oregon v. Leland, U.S. v. Davis, and just see that there has been variability on what is the presumption of sanity. So I think to understand this, it's difficult to understand. The best way to understand it is just on the presumption of sanity. Does the state have a right to make a defendant prove his sanity beyond a reasonable doubt, to put the burden on him? The state doesn't have a right to make a defendant prove he's innocent. But does the state have a right to make a defendant prove beyond a reasonable doubt that he was insane? The answer is yes. And so if the Supreme Court is willing to say that, then they're willing to uphold this really wacky reasoning in Arizona about how experts can or can't present evidence. I think that's sufficient to let's see this last slide here. I know what I want to. I want to just add a statement from the dissent. So the dissent is very passionate that this is terribly unfair, what Arizona is doing. That these rules about what mental health experts can do to present evidence to negate specific intent, it's all very odd. But one of the dissenters here says it's somewhat striking that while the court discusses at length the likelihood of misjudgment. What's the misjudgment? What the court is saying is that, hey, look, experts can confuse people. It's a ridiculous argument. Experts can confuse people. Well, We could go to any other cases in the Supreme Court, and they would talk about the wheel of cross-examination. It's a very weak and petty position for the majority to take. Well, that can be confusing. That's what cross-examination is for. But to say that Arizona's, it's all right for them to do that because we don't want experts testifying because they can be confused. It's somewhat striking that while the court discusses at length the likelihood of misjudgment from placing too much emphasis on evidence of mental illness, it ignores the risk of misjudging an innocent man guilty from refusing to consider this highly relevant evidence at all. And I agree with that statement, as I would assume most mental health professionals would. Let's get the evidence in there. Don't be afraid of evidence. Get the evidence in there. If you want to do something to reduce confusion, do something to reduce confusion. But just having different points of view and saying that the jury would be overwhelmed by this, I think is a very, very low opinion of a jury. Okay, thanks very much.